Welcome to Law You Should Know. The law affects every aspect of our lives, our home, our jobs, and our recreational activities. Now you can learn about the law and how to protect yourself against the loss of your liberty or property. Learn how to stand up for your rights and seek compensation when you have been wronged. Your host for Law You Should Know is attorney Kenneth J. Landau with the Mineola law firm of Shane, Dox, Denisi, and Corker. He's a member of the Committee on Professional Ethics of the Bar Association of Nassau County and counsel to the Nassau Academy of Law. And now, here is your host for Law You Should Know, attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome to Law You Should Know. Today we have a special program, and attorneys can also earn CLE by listening to the program. You'll get details shortly on arbitration agreements, how they can be important to lawyers, their clients, and the general public. And my guests for today's programs are Elan Weinreb, who's the principal of his own firm in Garden City, the Weinreb Law Firm, and also Anna K. Mitchell, who's with Redmond Law, located in Manhattan. And Anna devotes her practice to arbitration, and she also has a master's in laws in arbitration and dispute resolution. And Elan is very involved with the Nassau County Bar Association ADR committee. Welcome to Law You Should Know.
Thank you, Ken, for having us.
I know you have a lot of interesting points to cover. And again, attorneys can earn credit by listening to the program. We'll give you a special code and more details later in the program. What happens when people sign arbitration agreements?
Well, when anybody signs an arbitration agreement, they have to understand that to a certain extent they're not necessarily sacrificing, but they are compromising or taking a position on certain rights that they have. Whenever a person does end up getting into arbitration, which we should define what it is, arbitration's a private, confidential, alternative dispute resolution process that's similar but not identical to litigation or going to court, that involves one or more neutral decision makers. Those are the people we call arbitrators. Or arbiters. The process is such that the arbitrators or the arbiters have a certain measure of control over the process, such that the person who would be signing an arbitration agreement is giving control over to those arbitrators to resolve their dispute.
And Anna, did you want to add anything to that?
Yeah, I mean, I'd just like to point out, I think a lot of people actually sign arbitration agreements and don't even realize that they're doing so. A lot of us have the tendency when we're trying to get a new cell phone or, car lease, et cetera, to just sort of skip to the end of the tiny font and really just sign our names on the dotted line. But, if you parse through and you're reading, you'll really see even, employment agreements, credit card agreements, all of the above really incorporate a lot of arbitration.
And when people or business owners sign contracts, sometimes they may be signing arbitration agreements. And I know that both of you today are going to point out some of the pitfalls and some things they should be aware of, even if they don't have a choice and it's not negotiable.
Yes.
Yeah.
Okay, so let's just move on. Tell us more about arbitration agreements and what they entail.
Okay, well, an arbitration agreement, and just to give your listeners a heads up, if anybody wants more information on arbitration agreements or alternative dispute resolution, you could contact myself or the Nassau County Bar Association at 516-747-4070. They have arbitration and mediation panels. But what arbitration entails, getting back to your question, Ken, is the ability to resolve a dispute in a way which saves costs, time. It is speedier. It's certainly faster than going to court. And it's also confidential, which is an important point. It's not something which is exposed to the public. So when a person signs up for arbitration, he or she is gaining a lot of these advantages. And Anna has a nice way of describing arbitration as a bespoke trial.
Yeah.
Anna,
absolutely. I mean, what you can really do with an arbitration agreement, and that's why it's a very useful tool for business owners, who really want to be able to take a little bit more control over the process of resolving disputes, whatever they may be. An arbitration provision really allows you to select, the cost in terms of picking what kind of association you actually want to hold your arbitration through. It allows you to determine the amount of time, how much you're going to go into a discovery process. So it can really pick up the speed and allow costs to be evaluated more.
And also gives you control over scheduling. Mm-hmm. In court, the judge is going to tell you when you have to be there and what you have to do. in arbitration, there's going to be more flexibility to work it out for mutual convenience.
Absolutely. You can give a time frame initially and say we want all parties to exchange documents within 2 months, for example.
Or when the hearing will be held.
Absolutely. Yep.
And actually, arbitration in some ways is very much in the popular conscience because we have a variety of television programs which people think are representations of court proceedings, but they're really not. If you ever see The People's Court, for example, or Hot Bench, those are two very popular shows right now that are really arbitrations. They're not true litigations or true small claims court disputes. You can see that from the introduction to the People's Court, which I pulled off. Both parties have agreed to drop their claims and have their cases settled here. It's not that they're settling their cases. They're really just having them arbitrated by a neutral third party in a confidential forum, although it's not confidential anymore because everybody sees them, but that's their choice.
Go ahead.
And that kind of just leads into the point that when you're looking at these agreements, there are a whole different range of sizes for arbitration clauses. So that's something.
What are the most important things that someone should be aware of?
Well, one, that it's actually there, and then two, the extent to which, the clause actually provides for how the arbitration is going to be held. So, that's something that, Elan might address a little bit in terms of the simplicity or the complexity. And
yeah, there's varying types of agreements and clauses that we're going to get into, but just to give the world here an idea of some of the variables that go into any specific arbitration agreement, there's a program that is run on the AAA, the American Arbitration Association website called Clause Builder, which I do not recommend you use it yourself. You should have an attorney if you're going to be using this to create an arbitration clause. But just to give you an idea of the types of variables or things that go into the agreements, you have the type of contract or dispute that is going to be involved with the clause, whether or not the dispute to be arbitrated is going to be an existing dispute or a future dispute, whether or not what Anna was referring to before, you have a simple or a complex arbitration clause, meaning you have other procedures, preconditions, such as mediation, which is a different dispute resolution process than arbitration. Before arbitration, the number of arbitrators are involved. You have one, you have three, do you have more, do you have less? The method of arbitrator selection, what sort of strikes do people have against the arbitrators? Are you going to follow the rules of a provider like the AAA, or are you going to have your own system? Arbitrator qualifications, does the arbitrator have to have a specific type of expertise in patent cases or IP cases? You have the provisions dealing with the arbitration takes place, that's locale, governing law, what specific law would apply, discovery, whether you're going to have some sort of depositions or other type of discovery process, and maybe derogatories between the sides. Interrogatories are rare and depositions are also rare, but certainly document exchange is very much common in arbitration. Is it the hearing that would be involved in arbitration going to be a documents-only hearing, or is there actually going to be testimony by the parties involved? The duration of the proceedings, how long they're going to go for, what remedies are going to be available to the parties. For example, sometimes people have limitations on punitive damages. You find this very often in Better Business Bureau arbitration. The assessment of forum fees and attorney's fees, who has to pay what and when, the opinion accompanying the award, what type of opinion is it? Is it going to be detailed? Is it going to be simple? There's even provisions regarding confidentiality with respect to what the parties can say regarding the arbitration. Obviously, as I said before, in the People's Court, people are more open there, but in other arbitrations, things have to be kept under tight wraps. There is provisions dealing with non-payment of arbitration expenses. Unfortunately, people suddenly decide that they're not willing to go forward with the process. They stonewall. What then happens to the whole process? Can you go forward? Can you not? And last but not least, the last variable you have from over here is appeal options. Can the parties take an appeal of an award internally within the rules or frameworks set up by the provider, or outside of that framework? So there are a whole bunch of variables here.
And anything you'd like to add to that?
Yeah, given all of these factors, when you're looking at these agreements, they can be really simple. It can even just say the parties must submit to an arbitration. It might not even specify the forum, the time frames, the number of arbitrators on your panel. Is someone better off, whether an individual or business, if there are some more details? It completely depends on the nature of the business, and that's definitely a very big reason for why you want to be working with an attorney in terms of structuring your agreements.
Especially if enough is at stake.
Absolutely. And that's the thing at the end of the day, too. As a business, you need somebody who's going to help you really anticipate what kinds of disputes you might have in the future, and then how incorporating dispute resolution provisions in your agreement is actually going to play out in the long run. So, for example, if it's a more complex, multi-tiered provision that might require you to submit to mediation before you can actually go to arbitration, you really want to think okay, were we going to just be stalling the process of getting to arbitration by going to mediation because we're obviously at the point where we're not able to reach some sort of resolution? So looking into the complexity level of the clauses is very important.
Do you think that's a big negative to have mediation before arbitration?
I don't personally think it's a big negative. I think that it just depends on the nature of the dispute. And, the timing and effectiveness of some dispute resolution processes is really dependent on the nature of the case.
Okay. And one key thing, and I think it was mentioned, is the arbitration agreement may or may not specify who the provider is. And if it does specify a provider, you're bound to their fees and also their rules of evidence and their procedures.
Right. That is generally correct. Just a point in general, in most arbitration forums, the rules of evidence do not have to be strictly adhered to. You can obviously alter that by agreement, that the proceedings would be conducted like you would have in court with various hearsay rules and what else applicable. But more often than not, it's usually the case that the rules of evidence are relaxed.
Right. But the provider's rules might detail to what extent they're relaxed.
Correct. In other words,
Absolutely.
that usually involves considerations regarding weight of the evidence as opposed to admissibility.
And even whether an expert has to be there in person or their written reports can be submitted, which can make a difference in the expenses. What about counterclaims? I mean, when you go to arbitration, you're giving up your right to a jury, most cases giving up your right to appeal. It's going to be binding. What about counterclaims? If you were sued, normally you'd have a right to bring a countersuit. Your countersuit has to go through arbitration.
When you submit to an arbitration agreement, you are essentially waiving all ability to go to court except for involving disputes as to whether or not you are subject to the arbitration provision.
But
so
can you
when
bring
you're
a
there,
countersuit within the arbitration?
Absolutely.
But you then have to pay fees if there's a fee clause based on the amount you're suing for.
It completely depends on the organization that you're working
But
with.
it's something to be aware of, that it
is.
could be a hindrance. And also the fees can be a hindrance. If a person go to court for very little money, and except for the legal fees, but there are very few administrative fees, arbitration fees, you're paying the lawyer, but you're also paying perhaps half, perhaps more of the administrative fees and the arbitrator's time. The judges are working for free. They're paid by the government. So it's just something in a smaller matter, or if you're involved in a small business or individual, it's just something to be aware of.
There are a lot of factors to consider, and that's absolutely why you should work with a lawyer.
There's also this situation, though, sometimes where people bring counterclaims and they're not within the scope of the arbitration agreement, in which case you'll have fallout or spin-off litigation regarding whether or not those counterclaims really should be arbitrated. And if people are interested, you could take a look at the case Fujifilm versus Galeshmal Enterprises, decided in the Eastern District in New York on March 9th, 2017. You'll see some of those issues are present in that case.
And can you tighten up the language in an arbitration agreement if you so choose, so that any and all counterclaims would have to be brought in? Or
Absolutely.
Just only counterclaims which are the subject of the contract?
I think that's kind of the amazing thing about this process is how much you can really design how you want the arbitration requirements to function for you.
And so it's basically a contract issue. That's part of the contract, and that the wording or the lack of clarity in the wording can be very important down the road. And that's another reason you need a qualified attorney.
Yes.
To review it and draft it and understand your options. We're going to take a short break now. When we continue our discussion, we'll continue our discussion in a moment about arbitration agreements. Our guests are attorneys Anna K. Mitchell with the firm of Redmond Law in Manhattan, and Elan Weinreb, whose principal is his own firm, the Weinreb Law Firm in Garden City, Long Island, New York. You're listening to Law You Should Know here on 90.3 WHPC. Also over the web at ncc.edu/WHPC. We'll be back in a moment.
This portion of programming on WHPC is brought to you on behalf of the Nassau County Bar Association, who wants you to know about ADR, Alternate Dispute Resolution, which can help you avoid costly, lengthy, and uncertain litigation in court. By resolving disputes through mediation or arbitration, it gives you control over who decides your case. A mediator helps all parties to reach an agreement they can live with, or an arbitrator selected by the parties hears and decides the case. Your attorney can still represent you, but you control who decides your case. ADR is faster and less stressful than fighting in court, and it is a great way to resolve divorce, employment, or commercial disputes. ADR is now offered through the Nassau County Bar Association. Find out more about how ADR can help resolve your dispute by calling 516-747-4070 or visit nassaubar.org.
Once again, we continue with Law You Should Know. From the Mineola Law Firm of Shane, Dox, Denise, Corker, and Sauer, here is attorney Kenneth J. Landau.
Hi, this is Ken Landau, and welcome back to Law You Should Know. This program is about arbitration agreements, and attorneys can earn CLE credit by listening to this program through the Nassau Academy of Law. You will have to pay an administrative fee to them for the credit. You can contact them at 516-747-4070. That's 516-747-4070, or visit the website on the internet, nassaubar.org. My guests today are Elan Weinreb, and he's principal of his own firm, Weinreb Law Firm in Garden City, Long Island, New York. He also is very involved in arbitrations and is involved with the Nassau County Bar Association ADR committee. And joining us also is Anna K. Mitchell, who's with Redmond Law, and her practice is devoted to arbitrations. And she also has a Master's of Law degree in ADR and dispute resolution. And attorneys, listen for the code at the very end of the program. One way or another, pursuant to the arbitration agreement, we've had our arbitration, and the parties may or may not like the decision. What can they do about it, Elan?
All right. Well, challenging an arbitration award, generally speaking, is very difficult, and I'm going to let Anna chime in a little bit more about this. But the fact is that if you want to try to go and knock out an award, what's called vacatur of the award, you're going to run into some significant obstacles because they're very limited grounds for doing so.
Yeah, absolutely. Generally, there are only a few very, very, very limited circumstances where you can have an award actually overturned or, go back to litigation. One of which is that it was procured through corruption, fraud, or undue means. Another is that it exceeded the jurisdiction of the arbitrators, or it was a subject that was not properly submitted for the arbitration, or that postponement of an arbitration was actually wrongfully denied. So, and then, in terms of also modification of an award, that's also incredibly limited. So in order to do that, let's say, the award is rightfully before the arbitration panel, there has to be either a miscalculation of figures, or it has to be imperfect as to form, or the determination is something that shouldn't have been actually decided by the arbitration panel, and in terms of the merits, it needs to be corrected.
And what if there's not quite bias, but there's some type of conflict of interest? Perhaps one of the parties or one of the counsel had some type of good dealings or bad dealings with the arbitrator.
Well, in that situation, you would probably have a basis for a motion to vacate for a vacatur of the award. But again, it would be involved with the issue of disclosures. If there were proper disclosures made by the arbitrators, which is required by all arbitration forums in all aspects, then depending upon the level and the nature of the disclosures, it very well might be very difficult, if not impossible, to challenge them.
And if you've waived it either implicitly or explicitly, should the litigants or the parties ask the arbitrator up front? Is there anything you feel you have to disclose?
No, generally speaking, the rules require the arbitrators to make mandatory disclosures at all relevant points, but obviously before hearings or even
And does it have to be the most minor things? They had dinner 10 years ago?
That's really unlikely.
I'll tell you
more
this
egregious.
much. I've seen certain forums that require their arbitrators to disclose any type of relationship, whether it be financial, personal, social, family, or anything.
Well, I don't remember the outcome, but I know there was a big case that was reported recently in the Law Journal about possible conflicts about arbitrator, and they were seeking to knock out the arbitrator or knock out the award on that basis. And I don't remember the outcome. Anyway, about vacating the award, let's follow up with that.
And that's just something you really want to be mindful of, I suppose, when you're agreeing to arbitration.
And the other thing in terms of a vacatur that you have to realize is that very often whether or not you can strive to accomplish that goal is dependent upon the scope of the arbitration agreement in the first place, which really is what we've been getting to. The point is that when arbitration agreements are extraordinarily broad and they have tremendous reach, it becomes that much more difficult to vacate an award because the courts are going to, first of all, go to their public policy in favor of arbitration, which is spread out through God knows how many cases. And in addition to that, they are also going to state that when parties sign a contract, they're going to go back to the traditional interpretations of contracts principles that we all are familiar with as attorneys. And just for those who are not familiar with them, generally contracts are meant to be enforced as they are read by the parties. The courts are not there to reform agreements. And all of those classic principles go back to say that when you have a broad agreement, you're going to essentially be bound by the terms of that agreement.
And for that reason, should the parties consider limiting the scope of the agreement, the breach of that paragraph?
Parties should absolutely. I mean, again, it completely depends on the nature of the agreement that you're entering into and how much you may or may not want to limit it. For example, if you're dealing with like a construction case, you might really want to consider exactly, the forum, because if you're in front of AAA, for example, or JAMS, they have a lot of people who are really experienced in construction. So you're able to, cater your case to somebody who really understands the issues. I'm sorry.
And they're going to have a specialized panel.
Yeah, a specialized panel. That's incredibly important. So in a case like that, yes, you want to be a lot more specific. You want to make sure that your case is going to be in front of the right people.
And do you have to specify that in the arbitration agreement, or by specifying a particular provider, you're getting that automatically?
If you specify a particular provider, those rules are coming in automatically. If you're not, you might want to consider being a little bit more specific.
And sometimes what you could do is you could use the sub-rules within a specific provider's rules to get to that goal for your objective. For example, if you're dealing with AAA, you want to have your arbitration before the American Arbitration Association, you can specifically state to use their commercial rules as opposed to different types of rules. And by doing that, you are very likely you're going to get arbitrators who are going to be familiar, obviously, with those rules, and the rules themselves will lend themselves to more specialized types of arbitration.
And go ahead.
Yeah,
Anna.
I think something that's really important to note too is that when you're entering into these agreements, there are some that you can negotiate, and then there are some that you cannot. If you're going to Verizon or some other cell phone provider, you're not going to be negotiating your agreement. You're subject to whatever those provisions are, so just know what they are. If it's something that you actually can negotiate, then hire a lawyer, spend the time, think about it.
Right. If you're buying a contract for goods or for construction or for, let's say, employment or for some kind of services, it's advantageous to understand and negotiate the agreement, because after you sign it, you have lost many of your rights and your leverage.
And that's why, especially with employment agreements, there's a lot of litigation over whether or not, or class action lawsuits. There's a lot of litigation over whether or not you're subject to an arbitration agreement. And the only way, once you've actually signed on and agreed to essentially evade that process and be able to go to court, is if there's a statute that says the arbitration agreement is not enforceable.
And most agreements say that that the scope of the arbitration is any dispute arising out of the agreement that it's included in, as opposed to any disputes about anything between the parties?
Yes, absolutely.
But you could have it broader?
Yeah, it depends upon whatever the parties want. But generally speaking, usually, and especially in the commercial and business context, it's going to be defined by the scope of the business relationships between the parties. Sometimes, as I was mentioning the case before, the Fujifilm Galeshmal cases, sometimes you have different bodies of law which will determine the dispute based upon what goes on. For example, if you have one set of contracts that was subject to an arbitration agreement versus another set of business dealings or contracts that were not subject to an arbitration agreement, sometimes you'll get a court, as the court did in that case, to split the baby. But it's not always the case.
And you've mentioned them before, but just to expand them a little bit, the governing law could be very important. Which state is going to be the source of the governing law?
Yeah, as in any case, and even in litigation, the governing law is extraordinarily important, because the law of whatever state or jurisdiction is going to apply, if you're dealing with an international context, will also determine the power sometimes of the arbitrators.
And also the venue might be important for convenience or for the people on that panel.
Yeah, absolutely. And I have one potential case now where the litigants decided to have their dealings in Florida, but for whatever reason they decided to have any dispute arbitrated in New York. And as a result, you have a situation where their dealings were governed by Florida law, but they are going to be involved in an arbitration in New York.
And we talked about it before in terms of David and Goliath. One party, the legal system is essentially free, and you just have to worry about paying the lawyer who may or may not work on a contingency fee. But if you're bound to an arbitration agreement and you feel you've been aggrieved, let's say you're the small homeowner, it might take a certain amount of money to pay up front the administrative fees or your share of them to start the arbitration proceedings. And it's just something to be aware of.
Absolutely. And the fees are really going to depend too. If you're subject to an arbitration agreement where you only need to hire one arbitrator versus an entire panel of arbitrators, that's going to have a huge impact on your costs.
But it still may be a few $1,000s as opposed to just a few hundred for buying an index number.
Sure.
We just have very little time left in the program. What other tips do each of you want to wish your clients knew about arbitration? Annie, I know you represent a lot of construction companies. What's important for them to remember?
Well, particularly with construction, you oftentimes have situations where there are multiple tiers of contracts and privity. So something that you want to pay attention to, especially if you're a subcontractor working on a project, is whether or not the prime contract between the owner and the general contractor requires you to be subject to a dispute resolution process.
And would there be something in the subcontract about it? Or even if there isn't, you may be bound by it?
No, absolutely. So for arbitration to be applicable for a subcontractor, it has to be specifically incorporated. So
but just the words arbitration might be enough.
Yes, absolutely.
Elan, what else?
My tip for anybody out there who's dealing with arbitration agreements is make sure you have an attorney, even if you are an attorney yourself. Have a second pair of eyes if you're an attorney, reading over the agreements that are going to be negotiated or alternatively involved in the arbitration if you're already stuck with an agreement. If you are not an attorney, you should definitely, a layperson, you should definitely make sure to have an attorney look over any potential arbitration agreement you would be signing. And certainly if you're involved in an arbitration, have an attorney representing you.
Because after you sign it, it will be too late.
Yeah, essentially that's what.
And it's a very important clause and a very binding clause in whatever the contract or agreement is.
Yes.
Yes.
Okay, I wish we had some more time for lawyers out there who want CLE credit. Again, you have to do it through the Nassau Bar Association. They're going to charge you a small administrative fee. But the code for the program is MIN 1981. MIN 1981. I'd like to thank our guests. Anna Mitchell from the Redmond Law Firm in New York, and as you know, she represents many clients in arbitration, and also Elan Weinreb of the Weinreb Law Firm in Garden City, Long Island, New York. And thank you both very much.
And just very quickly, again, just to wrap up, one thing that we didn't mention, Anna happens to be the co-chair of the NYCLA, New York County Lawyers Association ADR Committee. If you have any questions, you could go through NYCLA to get to her. Or alternatively, you can go through me and the Nassau County Bar Association. Their number, 516-747-4070. They have arbitration mediation panels, which are available to the community. Thank you.
Okay, thank you. And you're listening to 90.3 WHPC, the voice of Nassau Community College, also over the air at ncc.edu/WHPC. Please join us for another program on law you should know this same time next week. And also, many of these programs can be found on iTunes by searching WHPC.